What is up, everybody? James Madison here. If you haven't seen a police officer get his retirement snatched, well, you're about to. There's an officer that was in Port Orange. His name is Stephen Braddock. He did some shifty stuff with having a notary, which was committing a felony, sign a notary when the people weren't present. And this was an effort to get his brother off of the power of attorney and get his. And then his wife started taking money out, like $200,000 of money out of his parents' account. Well, you're going to watch what this board does. There's some heated exchanges here with the arguments. Now, Stephen Braddock is no longer a police officer. He also had some probation stuff where he was violated and rearrested again. But for some reason, all of his court case, they're all gone and expunged. Let's take a look at this video. Thanks for watching.
My name is Adam Levinson from the law firm of Klausner, Kaufman, Jensen, Levinson. And as you know, we are the special counsel today brought in for purposes of assisting the board with this forfeiture proceeding. My job today is not just to explain the law to you and to explain the facts, but to make sure you understand it. So I welcome questions, and here I'm going to defer to the chair and to Ken. If you wanted to be able to ask attorneys while we're speaking, I would allow it, or if you want to wait until we finish, but I do welcome questions. So now let me officially begin with the opening statement. So as was pointed out by the chair at the beginning of the meeting, when you signed up to be a trustee, you didn't necessarily sign up to do forfeitures. Maybe you signed up because you enjoyed investments. Maybe you signed up because the union thought this would be a good idea, or whatever other reason. But this, I presume, was not the reason you signed up. When the law is clear and the facts are established, when the law is clear and the facts are established, you are required, it is mandatory to do a forfeiture when the law is clear and the facts are established. So what do I mean by that? And I'm going to describe to you what I'm going to go through. I'm going to give you a roadmap. But at the very outset, when the facts are clear and the law is established, what does that mean? That means in this case, when there is a no contest plea, and we're going to talk about what that means, when there is a no contest plea to a specified offense, and here it's two specified offenses. So when there's a no contest plea to two specified offenses, and those specified offenses are specified offenses because of what's called the catch-all provision. So when you have specified offenses under the catch-all, and when you have a no-low plea to both of those offenses, you are required by law to do a forfeiture. We don't like doing it. It's not fun. It's not why you signed up, but your hands are tied when the law is clear and the facts are established. I have the burden of proof today. I have to prove to you that the facts are established and the law is clear and that there is a nexus. So I'm going to spend a fair amount of time walking through the evidence for why there is a nexus, a connection under the forfeiture statutes. Let's start with the Constitution. And you'll see it says at the top, FLCONST. That's an abbreviation for the Florida Constitution. And that's an abbreviation for Article 2, Section 8. So everyone should be able to pull out Article 2, Section 8 of the Florida Constitution. So we're starting at the very highest level of Florida law, the Florida Constitution. What does the Florida Constitution say? And I'll read that first sentence for you. A public office is a public trust. The people shall have the right to secure and sustain that trust against abuse. The people shall have the right to secure and sustain that trust against abuse. And to assure that right, the Constitution, Article 2, Section 8, has a bunch of provisions. But the provision that we're here to discuss is subparagraph D. So the public office, and when you're a police officer, you have a public office. That's a public trust. What does paragraph D say? So the Florida Constitution describes and mandates that any public officer or employee who is convicted of a felony involving breach of public trust shall be subject to forfeiture, and it talks about public retirement systems. So if it's a private retirement system, an ERISA plan, or if it's any other kind of retirement system, that's not governed by the Florida Constitution. This applies to public retirement systems, which is what you are. So let me pause. Are there any questions? And I'll also point out to you that because of this constitutional provision, the Florida legislature, as you'll notice, it says at the end of paragraph D, as provided by law. So the Constitution speaks at a very high level. The Constitution gives the broad parameters, the broad brush strokes, subject to as provided by law, and that's how we get into the actual statute. But the first thing some of you may ask is, well, this case involves a no-low plea. It does not involve, somebody might say, a conviction. There was no jury here. There was no jury trial. The judge didn't have a trial and then make a decision after a full trial. So some of you may say, in order for the forfeiture statute to apply, there has to be a conviction, but this was a no-low case. So a conviction is defined as a plea of nolo contendere. So although you may not be logical, you may not necessarily come to that conclusion, the statute, this is the Florida legislature, tells us what we have to do. The Florida legislature said that a nolo plea is a conviction. It's a definition in the statute. So there are several offenses which are specified offenses under paragraph E. So some of them in the statute are spelled out, they're enumerated. So for example, and we're not here under E1, E1 is embezzlement. Embezzlement of public offenses or embezzlement of public funds, that's a named specified offense. So paragraph 6 talks about in committing any felony. Let me stop right there. Any felony. So if it's a felony, you start with paragraph 6, if it's a felony, but it's not enough that it could be a felony. So I'll give the example that if somebody steals from their neighbor and it's not connected to their job, if there's no nexus, if your neighbor leaves a door open and leaves their ring on the table and you steal the ring from your neighbor, if there's no nexus, there's no connection to your job, you can get away from a forfeiture standpoint with what you do in your own time. But when that felony, which is what we're going to see, is connected to the job, when there is a nexus, that's what requires the forfeiture. So let's keep reading from paragraph 6. The committing of any felony by a public officer or employee willfully with the intent to defraud the public or the agency for which the public officer or employee act, in which he or she is employed, of the right to receive the faithful performance of their duty as a public officer. So again, this is what the catch-all requires. Realizes or obtains or attempts to realize or obtain profit, gain, or advantage for himself or herself or some other person through the use or attempted use of the power, rights, privileges, duties of the position of their office or employment position. So I will be prepared to give you examples of cases, some of them very prominent people who were not convicted or did not plead guilty to an enumerated offense, but it fell under the specified offense. They went to jail, they lost their pensions. So under the pension ordinance, which is intended to replicate the statute, if you plead no contest, that's the same thing as a conviction, and that's in your pension ordinance. The first offense where there was a no contest plea is section 831.02. 831.02 Florida statutes. And that offense is called uttering forged instruments. Uttering forged instruments. What does 831.02 say? And I'll read it. Whoever utters and publishes as true a false, forged, or altered record, deed, instrument, or other writing mentioned in section 831, knowing the same to be false. The point is that uttering, it's not enough that you're passing on or innocently passing on a false document, but if you pass on a false document, even if you're not the one who falsified it, but if you pass on a false document, knowing the same to be false, with intent to injure or defraud any person, is guilty of this offense. The next offense is section 825.103, to which the respondent pled no contest to 825.103. 825.103 is called exploitation of an elderly person or disabled adult. Exploitation of an elderly person or disabled adult. It's a very detailed statute. I'm just going to read to you relevant provisions. An elderly person's or disabled adult's funds, assets, or property with the intent to temporarily or permanently deprive the elderly person, and it goes on, of the benefit of those funds. So let me take a step back, because it's important that everybody understand this, and I welcome questions. The exploitation statute says is if you are in a position of trust, almost if you're a trustee or a position where you can take advantage of them, and you use that position to disadvantage them and benefit yourself, that's what triggers the exploitation statute. October 14th, 2021, the respondent pled no contest to one first-degree felony of exploitation of an elderly person under 825.103.3a, and one felony count of uttering under 831.02 in case number 19-305649 CFDB in the 17th Judicial Circuit in Volusia County. That was on October 14th, and in the materials is a copy of that plea colloquy. On November 30th, so a little bit more than a month later, the original plea, which was to a first-degree felony, was vacated, and a no contest plea to second-degree felony exploitation was entered under 825.103.3a. The original plea was vacated, taken out, and instead you had a plea to second-degree felony. But the same offense, the only thing that changed was the dollar amount. So on the nexus facts is what I'm calling them. Solana was the notary, and some of you may know Solana. So she's a notary, and Solana uses her notary stamp at her desk to notarize the documents that are uttered. So the fact that she was employed by the police department is Exhibit 20, her deposition, page 7. Exhibit 13 is her pay slip, which, by the way, gives her salary at the time she's notarizing the documents on page 1 of Exhibit 13. The Internal Affairs report, which goes into great detail with interviews with Solana, is Exhibit 12. Page 2 establishes that she's with departmental personnel, that she's an employee, and that her job is records clerk. Exhibit 20 of her deposition establishes that she is a notary for the police department, and part of her responsibilities as the record clerk is to do notarization. Exhibit 12 is the Internal Affairs report, that the documents were notarized at the police department. She notarized these documents, the durable power of attorney, when she was on duty at her desk. Exhibit 20, page 10 again, the notarization of the DPOA, the power of attorney, the durable power of attorney, occurred on duty at Solana's desk in this building. The notarization of the warranty deed was also done on duty. That's page 13 at Solana's desk. That is your nexus, trustees. Had the respondent taken these documents just to a bank and had them notarized, we may not be here today. Now that case may have different facts to it, but we're here today with a case where the notarization did occur. And some of you may say, so what? Some of you may say, this is just, a notarization of 2 documents. Had someone brought documents to be notarized to a bank, a notary who was doing their job, who wasn't effectively being asked to do something by a superior officer who they report to or might report to, a notary is required to do a couple things. 117.107 provides that a notary may not notarize a signature if it appears the person is mentally incapable of understanding the effect and nature of a document. So if the mother, with all due respect, who is in a assisted living facility, but if the mother is not mentally competent and capable of signing something, a notary can't notarize it. That's 117.1075. The notary statute 117.1079 requires the person whose signature is being notarized be present. When these documents were notarized, the only people at the desk, when that City of Port Orange notary seal was used, paid for by the city, the only people in the room were the respondent and the city's notary, Solana. The 2 witnesses who were effectively supposed to be agreeing to these documents were not present. So what is the point? The point is that had, in theory, someone gone to another outside notary, the outside notary would have wanted to make sure that the person who is signing a document is capable, because that's what the notary statute says, and they would have had to be physically present, but they weren't. So this is not just a notarization case. This is a notarization case done in an unlawful way. And I'll also point out to you that it's a felony under the notarization statute to do what occurred, which is a false or fraudulent acknowledgement, is a 3rd-degree felony in and of itself. Another connection from the Solana deposition is Exhibit 20, page 9, that Solana knows Braddock because he was a sergeant. And that's another thread that you see in some of these notarization, in some of these forfeiture cases, that when a police officer meets someone through their job, that can establish a nexus. So here, Solana testified she knows Braddock because of her work. He was a sergeant, and that's how they met, was through the job. But even if they hadn't met through the job, they used the instrumentalities of the office, of the notary seal and the notary process. And again, it was no coincidence that the respondent selected a notary who would assign whatever he wanted, rather than taking it to an independent 3rd-party notary who's going to comply with the notary statute. Are there any questions on the nexus in this case?
All right. You've just heard quite a bit of information, so I'm not going to belabor too many of the points, but I would like to make a few points of my own and, of course, a few corrections. Specifically, with regards to the statute 112.3173, as codified as well by the city code, we've been discussing the paragraph 6 ad nauseum, in fact. I'd like to point out that we need to not only look at the portions of the statute as they're written individually, but you have to read to the bottom of the page. You have to read completely the entire paragraph. Specifically, my client did not use his position as a Port Orange police officer to have the notarial documents ratified. Anyone can walk through the front door of the Port Orange Police Department and request notarial services. In fact, that was testified to in both Lieutenant Aiken's testimony as well as Ms. Solana's testimony. He didn't use his position to force her to notarize anything. She was ultimately the notary. She was the person that took the course. She was the person that was aware of the notarial statute. My client had no reason to review the statute or take the 4-hour course necessary to become a notary. And he was unfamiliar with the statute as it was. His question to her was, can you notarize this document? And her answer evidently and obviously was yes. My client was unaware and therefore did not have the willful or intentional portion that you would have to find in order to have him forfeit his pension as a result. There was no intention to defraud. There was no willful anything. My client was unaware of the fact that perhaps the notary stamp shouldn't have been used. My client was unaware of the fact that maybe the document shouldn't have been notarized. He is not familiar with that statute. That's not something he used on the job every day. And as a police officer, it's not necessarily something that you would know. He had a notary notarize a signature. He had the signatures of both of his parents. He had everything. He checked all the boxes. The document was prepared. It was properly signed. Then it was notarized. Unfortunately, not in the right order, and unfortunately, not all at the same time. But my client didn't know that would make the document invalid. Therefore, I think that you'll find that the willful and intention to defraud the public or the public agency is not present in this case.
And looking at the pension ordinance, that part isn't in there about the willful public trust, committing of any felony by a participant. Okay, you said he didn't know, and I don't know what he was thinking or whatever, but
correct.
They weren't present. He's a sergeant. He's a police officer, a career police officer. He should have known that the parties had to be present to notarize a document.
Why should he have known that?
I know it.
Because you know it, he should know it?
I would expect the career police officer to know that the parties have to be present, signing a document.
And I understand that expectation, but just because you know it doesn't mean that he should know it.
Okay, all right, we can figure that, but he pled no contest to uttering a forged instrument.
To that end, it's worth noting that the actual definition of pleading no contest is that they're accepting the plea, but does not admit guilt. He accepted that he was being charged with the 2 offenses that were stated. It does not admit guilt. And in fact, adjudication was withheld. Does that answer your question?
Why not fight it then?
The issue with that, though, is the NOLO for purposes of pension revocation is the same as a conviction.
I understand what you're saying. Again, worth noting that actually pleading no contest is not admitting guilt, but I understand what you're saying.
Right. So for us, whether it means guilt or not, the plea of NOLO, statutorily, we're required to take it as a conviction, unfortunately.
But it wasn't a specified offense.
Okay.
That could be specified in any felony.
Right. The argument is that the specified offense is 6, which is any felony. I think is the argument that.
Well, the argument is that the specified offense is 6, but I don't think that you can find willful or intentional conduct, which is required under subsection 6.
I would agree with that in the using of the notary, but in the overall sense, I don't know that you can, if he didn't have willful and intentional in the use of the notary, doesn't mean he can't have willful and intentional intent to defraud overall. And that's what we have to look at. You can't just remove the willful and intentional and apply it only to the use of the notary, right? It's the overall. And the NOLO says for pension purposes, I did.
And I understand what you're saying, but with the specified offense, it must be demonstrated that it is willful and intentional. And that having been said, because I understand you're saying the overall offense is, if he didn't know that he didn't have an invalid power of attorney, how could he have possibly willfully or intentionally?
Well, that's exactly what he said to the judge when he pled no, that he understood the facts, that he did, when he pled no. As far as the pension is concerned, that's the same as a conviction. He said to the judge, I know what the facts are that I am charged with, and I accept those facts. Right? Those facts are now a matter of record.
I understand your position. Mr. Braddock, how long were you employed with the Port Orange Police Department?
Just under 24 years.
And were you in the same position each year, or did you change
I've varied
positions?
through different divisions
Okay.
throughout my career.
What was the last position you held with the Port Orange Police Department?
I was a motor sergeant. Covered a couple different other departments within that purview.
And at the time that you retired as a motor sergeant. And prior to your retirement in 2018, do you recall meeting Miss Solana while you were employed with the Port Orange Police Department?
Yes, ma'am.
Did you know her beforehand?
When I started working for Port Orange,
Correct. Did you have a relationship or a friendship with her outside of the police department?
yes, ma'am.
Describe to me that friendship.
Well, we would have lunch together periodically. She was her boyfriend Chad. We became friendly with them. I helped her out on a couple of different situations where she needed some advice.
Had you ever asked her to notarize anything outside of work or outside of the Port Orange Police Department?
Not that I could recall off the top of my head.
Okay. So once the document was notarized, you were under the impression that it had been properly executed and properly notarized. Is that correct?
Correct.
If you'd like to go ahead and cross. Feel free.
Mr. Braddock, you've testified before under oath. And you understand when you testify under oath, you want to make sure, did you take any medicine before today that might interfere with your ability to testify truthfully?
No, sir.
Have you had anything to drink today that might impede your ability to concentrate and understand the questions?
Any alcoholic beverages?
So it's going to be your intent to answer honestly, consistent with the oath that was administered by the court reporter.
Yes.
You testified earlier that there was a prior power of attorney that was not notarized by Solana, which was discovered at the assisted living facility, which is Manor Care, correct? There was a prior power of attorney.
Repeat the question.
Sure. I'm just referring to your prior testimony that there was a prior power of attorney that was filled out by your mother or father, which was not notarized by Solana years ago.
Right.
What did you not tell us about that prior power of attorney?
What didn't I? One more time with the question. I'm trying to.
So I'm giving you an opportunity to tell us, because your attorney thinks it's significant that Solana did not notarize the prior years ago power of attorney. I'm asking you if there's anything significant about that power of attorney that you're not telling us today.
Only that it was in place during the situations.
So the power of attorney that's the subject of this proceeding today had two people who were given authority under the power of attorney. Who were the people who had authority under the power of attorney from 2017?
People that were listed on this.
Correct. Who are the people listed on the document who were given the power under the durable power of attorney in 2017?
To clarify, he doesn't have that document in front of him.
Okay. So trustees, I want everyone to look at it. And the document we're talking about is document number 19. So who does power of attorney, the durable power of attorney, give the power executed in March of 2017? That's a power of attorney to you and to who else?
Clarification. Exhibit 19 is October 16, 2015. That's one over.
We'll talk about that. But yes, that's the date that's shown on the document is 2015. But the testimony today was that it was signed in 2017. But the date on the document is 2015. So I'm asking who had the power of attorney in exhibit number 19?
Objection, I apologize. That is a mischaracterization. I was referencing the deed, which was the document in front of my client, who read the date from the document in front of my client, which was the warranty deed and exhibit 1, as I stated when I presented it to him.
Let me repeat the question, which is the same question. Who does that power of attorney, which is document number 19, exhibit number 19, give the power to act as an attorney? Who does it empower? It's not intended to be a trick question.
Well, I'm not trying to,
Sorry, I didn't hear what you
I
said.
said it's not intended to be a trick question. Look at the first paragraph. I, Susan Braddock, if you want to read it, what does the power of attorney do? Who does it give the power of attorney to?
oh, myself and my wife.
To yourself, and who was the wife that's listed?
Mary Louise.
Okay, so the power of attorney, which has a date of 2015, gives the authority to act as the power of attorney, you and your wife, Mary Louise.
And I have, okay,
That's a yes or no question. Does it give the authority to act as the power of attorney, you and your wife, Mary?
yes.
Okay, now let's compare this power of attorney with the power of attorney which was located at the Manor Care, the assisted living facility. So you didn't tell us today. I gave you the chance to tell us. So here I'm going to tell you what the answer is I'm looking for. What is the difference between the original power of attorney from years ago versus this power of attorney, which is you and Mary Louise?
This power of attorney I put this together. And there was an incorrect date on it.
We'll come back to the date, but the main distinction I want to elicit from you is that the original power of attorney had two people on the original power of attorney, just as this one has two people, you and Mary. Who were the two people on the original power of attorney?
I don't object. We don't have the document in front of us. None of us can verify any of the information.
It's in the depositions. I'll give the record sites, and I'm asking the witness under oath, who was on the original power of attorney?
For my mother or for my father?
Let me back up. How did this case, this is a clue for everybody, how did this case come to the attention of the police department, triggering the internal affairs investigation? What precipitated this case being filed?
Are you asking for my opinion on that?
I'm asking you to answer to the best of your knowledge. What precipitated this case coming forward?
My brother. And my brother was on the original power of attorney for my mom. And my brother had not stepped up to the plate for any of this until he decided that he wanted to. I'm just trying to clarify that. I think everybody in this area knows that I was going through a great deal of stress and emotions and things of that nature that were associated with hardships with my family.
The original power of attorney that I'm referencing had two names, had Stephen and his brother Andrew. But the updated power of attorney, which was not notarized with the witnesses being present, and I'm not arguing, I'm just letting everybody understand the testimony, took Andrew off and added your wife. That was the consequence of the change in that power of attorney, correct? Adding your wife, taking out Stephen. I'm sorry, taking out Andrew.
And there's reason behind that.
I'm not asking you about that. Your counsel can ask you for the reasons. So, following the signature, if you will, of the power of attorney, which took your brother off and added your wife, would you agree payments started to be made pursuant to that power of attorney?
Yes.
That was the reason for the power of attorney, so the bank would follow your instructions and your wife's instructions, and no longer follow the instructions, by the way, of your brother.
Not to follow his instructions because they were not warranted at the time.
So I'm going to ask you now to read for us some of the dollar amounts on page 104 that are payments to Mary. So starting the top of the chart on 4/17 of 2017, what was the first dollar amount paid to Mary?
$1,000.
On 8/24 of 2017,
$1,000.
paid to who?
Mary Braddock.
Because now she's on the power of attorney, right?
Correct.
So she can go to the bank and get whatever she wants because she's now on the power of attorney. And Stephen's no longer on the power of attorney.
No, you're gonna clarify that.
Sorry,
Scott.
I apologize. The brother is no longer on the power of attorney.
Correct.
Correct, sorry. All right, on 10/18 of 2017, there's a large number. Could you tell us what that dollar amount is?
It is $200,000.
Who was that paid to?
That was paid to Mary Braddock,
Who was Mary Braddock?
my wife.
Did you know that $200,000 was paid to your wife on or about 10/18?
Yes.
From what account?
It was from my mother's account to a joint account, which we were also on my mother's account as well.
What's another organization or the name that you see in the middle of the page? I'll let everybody see it starts with the G. What is the name that starts with the G in the middle of the page?
Grace Manor.
What is Grace Manor?
That is where my mother was staying.
How long did your mother stay at Grace Manor?
Until Grace Manor decided to evacuate her because of a illness that she contracted allegedly from the location.
So you've just described the reason she was evacuated from Grace Manor was because of an illness. Is it not true that Grace Manor says the reason why it evicted her was because Grace Manor wasn't being paid?
There's an explanation for that.
Before you give the explanation, and I want to hear it, is it not true that the reason Grace Manor evicted your mother was because Grace Manor was not getting paid?
It's my understanding that they can't evict a patient or a resident for lack of payment. That was my understanding.
You know when she was evicted from Grace Manor?
I do not.
When was the money transferred out of the account? And you can answer that by saying approximately when was the power of attorney signed?
Which power of attorney you're referring to?
The power of attorney that took off your brother and added your wife.
As I recall, and I'm clear, my brother was removed from it 2017
2017. And when was the restitution paid?
thereafter.
How many years after? Rough idea. The original power of attorney had your brother. The revised power of attorney, which was the subject of this case, was 2017. And we went through a bunch of payments that were made, potentially, totaling $700,000. And I'm simply asking, how long did it take for you to pay restitution to your brother if the payment started in 2017 when money was taken out of the accounts? When does your brother finally get paid?
Objection, the brother was not paid. The civil settlement agreement specifically states that it was the estate, and that's why the order was.
Fair enough.
Estate.
When does the money get paid into the estate in which your brother will get?
It's clearly stated on the first page. It was made as of November 29th, 2020. Any other questions, comments? Does the board need me to summarize the proceedings here? Are you ready to confer about it? Quickly, if you could, the basis of the arguments are that nexus. The argument is if they're nexus, then we're under the catch-all, quote unquote. No nexus, no forfeiture. That's it in a nutshell. That's pretty much what you've been hearing. You hear one side supporting there is a nexus, and one side saying nexus is questionable. So you're ready to go unless you have specific questions. It's up to you.
So then I am going to have to ask for a motion to proceed with it. I'll make the motion to proceed with it. Do I have a second?
I will second that motion.
Andy made the motion.
Second.
I did, sir.
Second.
All in favor? Aye.
Aye.
And I'll prepare a final order.
Do we have any public comment? No, then a motion to adjourn? That motion to adjourn?
Make that motion.
Second?
I'll second.
Everybody seconded. All in favor?
Aye.